Good morning and welcome to the Supreme Court of the United Kingdom. Today we will hand down three judgments. The first is in the case of Test Claimants in the franked investment income group litigation and the Commissioners of Her Majesty's Revenue and Customs. This appeal is the latest in a series of appeals about the operation of a form of corporate taxation which no longer exists. It concerns principally the charge to advance corporation tax, or ACT, which was a tax on the payment of corporate dividends. It was imposed most recently by the Income and Corporation Taxes Act 1988. Under the relevant tax regime, the company paying ACT would set off its payment of that tax against its liability it incurred later to pay mainstream corporation tax on its earnings and gains. The group litigation involves financial claims by corporate taxpayers against the United Kingdom government for the repayment of tax levied unlawfully because it was in breach of EU law. The claims amounted to very substantial sums of money. Those claims were the result of a mismatch between the then relevant UK tax rules and the developing requirements of EU law. At the heart of the claims was the legal contention that the UK system of ACT discriminated against UK resident companies which received dividends from non-UK resident subsidiaries, compared with the tax treatment of dividends which UK resident companies received from their UK resident subsidiaries. The claimant's contention was that the differences in treatment breached EU treaty provisions which guarantee freedom of establishment and free movement of capital, and that contention was successful. This group litigation has resulted in 2 trials in the High Court, appeals to the Court of Appeal, and 3 references to the Court of Justice of the European Union. And this is the 3rd appeal to this court, which has also heard appeals in other tax cases that have determined points of law relevant to this group litigation. This appeal is concerned with 7 disparate issues, some raising questions of principle and others questions of quantification. It is possible in an oral hand-down to give only a very abbreviated outline of the outcome of the appeal on each issue. The first issue is a procedural issue. It is whether the revenue are barred from challenging a finding in principle based on a concession that the tax-paying company is entitled to an award of compound interest for the time value of money during the period in which it paid tax prematurely. The claimants argue that the revenue are barred by estoppel or on the ground of abuse of process from making this challenge in this group litigation. This court rejects that argument. There is no estoppel, as the issue has been decided only at a high level of generality, and the appropriate measure of compensation had not been determined. The Court of Appeal allowed the revenue to appeal on this ground, and this court allowed the revenue to withdraw their earlier concession in the light of this court's decision in the separate appeal in the Prudential Assurance case. Nor was there an abuse of process by the revenue, as this litigation and related proceedings have resulted in significant developments of both EU law and domestic law, with the result that important questions which affect this appeal have only recently or now been determined. This court's ruling that compound interest is not due for the period of prematurity therefore falls to be applied in this group litigation. Secondly, the question is, what is the basis on which the claimants are entitled to interest for the period when the tax had been paid prematurely, if they are not entitled to compound interest? The Revenue's appeal succeeds on this issue. Parliament enacted an entitlement to simple interest at prescribed rates in Section 85 of the Finance Act 2019. While the rates of interest are much less than the tax-paying companies claim, and interest is due for much shorter periods than the claimants sought, the statutory remedy does not breach EU law. The third question concerns the remedy which EU law requires where the tax-paying company has used its entitlement to double taxation relief in order to reduce an apparent liability to mainstream corporation tax, which was in fact unlawfully levied. On this matter, the claimants succeed. They are entitled to have the offending provisions disapplied to allow the carry forward of the unused double taxation relief, and insofar as mainstream corporation tax has been paid as a result of an inability to carry forward that relief, they are entitled to restitution of the tax plus interest. The fourth question is the revenue's argument that they were not enriched in English law by the receipt, by the receipt of unlawful ACT, because the payment of that ACT triggered an obligation on their part to give tax credit to the ultimate shareholders of the tax-paying company. This court rejects the revenue's argument on two grounds. First, on a proper interpretation, the tax credit to the ultimate shareholders was not conditional upon receipt by the revenue of ACT from the tax-paying company. And secondly, and in any event, EU law required the payment of the tax credit to the shareholders in order to avoid economic double taxation. The tax credits to shareholders therefore cannot be deducted from the compensation which the revenue must pay to the tax-paying company. The fifth question concerns a similar issue, which is whether the amount of unlawfully levied ACT which the revenue must repay is reduced if the UK group of companies had a foreign parent company which received a credit under a double taxation agreement. Again, the payment of the tax credit to the foreign parent is not conditional, or was not, upon the UK resident company having paid ACT, and the tax credit cannot be set off against the revenue's obligation to repay the unlawfully levied ACT. The sixth question involves a standstill provision in Article 64 of the Treaty on the Functioning of the European Union. The standstill provision could have prevented the Schedule D Case 5 tax charges from offending the EU law prohibition against restrictions on the free movement of capital, because those charges existed before the 31st December 1993. And the question is whether that standstill provision is applicable when the UK altered its rules in 2001 by introducing the eligible unrelieved foreign tax rule. This court agrees with the claimants that those rules caused the United Kingdom to lose the benefit of the standstill provision. The seventh and final question is concerned with how to calculate compensation due for unlawfully levied ACT, and it arises when a parent company has paid ACT, some of which has been lawfully levied and some not, and the ACT has been surrendered within a group of companies. The parent company had paid ACT but was not able to set off that payment against its liability to mainstream corporation tax because it wasn't due to pay sufficient mainstream corporation tax to use up the ACT. The parent company surrendered the unused ACT to a subsidiary to allow that subsidiary to set off the ACT against its own obligation to pay mainstream corporation tax. The reality is that the parent selected a particular subsidiary or particular subsidiaries to whom it surrendered specific sums of ACT. The court agrees with the revenue submission and holds that the ACT which was surrendered to a particular subsidiary should be treated as made up of lawful and unlawful ACT pro rata. I will now hand over to Lord Burrows.